On August 19, 2021, Rashawn Jones was indicted by a Miami-Dade County, Florida grand jury on a charge of second-degree murder in connection with the November 2006 shooting death of his University of Miami football teammate, Brian Pata. According to the investigation, personal tensions had existed between the teammates prior to the murder. Evidence later indicated that following the shooting, Mr. Jones drove to Miami Beach and allegedly disposed of the murder weapon by tossing it over a causeway. Furthermore, recorded jailhouse phone calls intercepted by the state captured Jones's wife explicitly berating him for leaking private details to a federal inmate named George Jones. The case was heard in the 11th Judicial Circuit Court of Florida before Judge Christina Miranda. Following extensive pretrial litigation, the jury trial began on February 19, 2026. On February 26, 2026, a procedural conflict erupted outside the presence of the jury. The defense attempted to argue that the lead detective had fed confidential case details to a jailhouse informant, George Jones, leveling severe misconduct allegations leading to a sharp exchange in the courtroom.
So Bernard Brinson is the individual who said that he heard this confession, and that's a separate individual than the victims in the case.
Brinson, who said he wasn't cooperating, and if he was called to the stand, he would tank the case?
No, that's a different person.
Bernard Brinson is the jailhouse informant who told the police that the person didn't confess to him.
Right, and who was given a polygraph that he passed.
Which is also inadmissible. So all of this, I know we're rehashing it.
Yeah, and Segovia followed up and investigated.
Right.
Well, when Detective Segovia said that it probably just, there are these jailhouse snitches who have something to gain and are
He
not
wasn't the only
credible
one, right?
And can't be relied upon. At that point, the fact that a polygraph was given and he passed that polygraph should have been used to impeach.
Right. It's not impeachable. It's inadmissible evidence, and I excluded it just like I excluded the jailhouse snitch who said that the defendant confessed to him that he had committed this crime. So, you can't use hearsay on one side and not the other. And the snitch from the jailhouse who's giving a statement made allegedly by the defendant would be admissible because it's by a party opponent. It's not in the inverse.
And there's a reason the state did not call that person, Judge, and the rules apply differently when it's the defendant's right that's the defendant's
The rules of evidence do not apply differently.
Okay.
The state could have called that witness. Just
Right.
for this record,
Right.
it's very clear. The state could have called this witness. We had him being transported from federal prison in July. The trial date got moved in July, and we canceled that. We ultimately made a strategic decision not to call him. There was voluminous discovery that we were disclosing to the defense, and there were other reasons we chose not to use him. But we could have called him. The defendant's confession to him had things that only someone who committed this crime would know. There are things that we could guess that were supported by the evidence that explained things that the evidence we had. It explained exactly what had happened, and it was very credible on its face. There are other issues and reasons we chose not to use
There's a lot of issues involved with that jailhouse snitch.
Jail calls.
Information that was fed to him by Detective Segovia.
And
Yes.
Where? Based on what?
Indeed.
Okay, this is...
Wait, stop. Ms. Peabody, I'd like to hear what that information is because I haven't been made aware.
If you look at the statement itself, everything that he said in there, those things that he said, was all information that the police had and was given to him. Everything that the police wanted him to say.
Where is that? Wait. Just a second, Ms. Peabody. I've noticed that you're a little upset about it, so I'd like to give you an opportunity since we're proffering for the record.
Okay, so since we're proffering for the record, Your Honor,
I haven't finished my sentence. I am addressing you, and I do want to hear from you. You're saying that the information that this witness brought to the police was information that the police fed to him first, and what are you basing that on? And just tell me what it is.
Because of the nature of the questions that were given by Detective Segovia to this witness in his statement, it's clear that that information, even in where he lived, where he was born, he was born,
where the defendant or
the jailhouse snitch said in a different place than he actually was born.
And that was honestly more credible to the state because the defendant had been living in
Just a second. So you're saying that the police officer the police officer fed the jailhouse snitch the wrong place where the defendant was born?
Yeah, that's what she just said.
Is that...
Your Honor, what I'm saying here now is this. The state keeps saying, and the court keeps saying, we could have brought in this witness. If you could have brought him in, bring him in. Nobody stopped you from bringing him in. But to say now that you didn't bring him in for strategic reasons, that's your decision. That's your decision.
Hang on a second. I don't know, the state made a reference to this witness. I made a reference that we're talking about snitches and their reliability. Both sides did not bring in snitches because of a whole bunch of issues. Ms. Peabody indicated something that I think is very important to flesh out, and I would like to gather the information. If the allegation is being made that a detective has fed information to a jailhouse snitch, I would like to have it proffered on the record so it can be investigated. I think it deserves I haven't finished. I think it deserves attention.
Judge Miranda demanded a formal proffer pursuant to Section 90.104 Florida statutes from defense attorney Benita Peabody regarding the allegation that Detective Segovia fed false information to one of the jailhouse informants, George Jones. Under Florida evidentiary and constitutional Giglio standards, a claim of investigative misconduct or manufactured evidence requires an immediate, specific offer of proof on the record. Judge Miranda also expressed her firm stance regarding the admissibility of the 2007 tipster, Bernard Brinson, who was not an active trial informant but had provided a statement regarding a different inmate's confession of killing Mr. Pata and was accepted in polygraph results. Under Section 90.803 Florida statutes, prosecution is permitted to introduce a defendant's out-of-court statements as an admission by a party opponent. The purpose of this hearsay exception is to preserve the integrity of the adversarial process by ensuring that out-of-court statements are only used against the making party, preventing the inverse introduction of unvetted third-party hearsay by the defense. The prosecution had originally prepared its actual trial informant, George Jones, to testify about an alleged confession by Rashawn Jones, but Ms. Peabody argued that the state deliberately withheld and manipulated the witness and that the underlying statement had been entirely fabricated. Conversely, regarding Mr. Brinson, the defense argued the state had committed a disclosure violation under Florida Rule of Criminal Procedure 3.220 and a constitutional Brady violation by withholding his decades-old polygraph files. Judge Miranda rejected the defense's reasoning regarding the admission of Mr. Brinson's third-party guilt theory, invoking uniform evidentiary standards and the strict nexus requirement established under Florida's state versus Savino precedent. The standard rules of evidence underscore that polygraph results remain strictly inadmissible and that constitutional protections do not create a separate, flexible application of the law based on the party invoking them.
What I've heard thus far is that the police officer told the jailhouse snitch that the defendant was born someplace other than where the defendant was born.
No, that's not what I said, Your Honor.
Okay.
I said that the information that he had was different than the truth. I also said that it is clear in the questions that Detective Segovia gave him that this was information that came from the police reports and not information.
Please give me an example so that we can follow up on this.
Okay, if you give me an opportunity to get to the statement, I will.
Yes.
Can we respond?
I would add.
Sure.
There are two things I would add. One is when we look at the George Jones confession, since the allegation is that the detective was feeding information, one of the things that the defendant tells George Jones in particular is
Are we litigating this one now?
he gets suspended from the team. He couldn't face his mother. He couldn't face his family back in Ocala. He had gotten, I guess, the coach thing was Randy Shannon basically told him he was never going to play again at the University of Miami, and his life, as he said, was done. There are at least three jail calls. I know because I listened to that. One in specific.
Ms. Peabody, please stop interrupting everyone. I'll give you an opportunity when it's appropriate.
One in specific is a jailhouse call in which he's talking to a male friend, where he talks about the fact that he had a conversation with Randy Shannon, and Randy Shannon told him that he was done on the team. There is another jail call that I have between the defendant and his wife, one in particular where he said...
Okay, just a second. Ms. Peabody said that's not true. At the end of this trial,
I'm going to send him right now.
I'd like to pull it up, because I'm hearing things saying that's not true.
The jail calls have already been provided to defense.
I know.
Those three in particular, the other two that I've referenced previously is one where the defendant is speaking directly to his wife, where he tells his wife, here's the phone number, 786, to attorney Michael Cohen, because he would like, George Jones would like a Rule 3 filed for him. Michael Cohen, who did represent George Jones. And there's another call from the wife yelling at her husband, back to the defendant, saying, why would you have given George Jones my information? Why would you have done this? Why would you have connected this together? Why would you have told him personal information about me? The fact that I live in Ocala. So let's just be abundantly clear that while the allegation is that the detective is allegedly slinging stuff, The defendant is the one who made the comments to George Jones, and there are jail calls that back up what he tells, in support of what he tells George Jones. In addition to the fact that he goes to Miami Beach that night, he throws the firearm over the causeway and into the ocean. That is in the George Jones statement.
Okay, why didn't you bring it? Why didn't you bring it?
That's all.
What I don't need to act. That's how they decided to prosecute. Hey, hang on a second. Just a second. You seem to be very riled up about this defense. The allegations that are being made are being refuted by the state, saying they're in the jail calls, of which Ms. Peabody asked a lot of times for me to ask the state to tell her which calls were going to be referred to, because there were over 400 calls and she hadn't gone through them. So I'm going to give her the benefit of the doubt that maybe she hasn't heard those calls and was making this allegation because she wasn't aware that they were in existence. Is that wrong, Ms. Peabody? Are you aware of those calls and still making this accusation, or maybe not?
I have not heard that call, Your Honor, but I will tell you this. What the prosecutor has just said does not equal to a confession. She's talking about innocent things there. The wife called to an attorney for somebody to get a bond, and for the wife to say, don't give my number. How does that equal a confession?
Well, I think what she was
So if you're saying that this is what George Jones brought to say that there was a confession, there's no confession.
No. That statement wasn't the confession part. That statement was to corroborate the information that would only... I haven't finished. That would only be known to this person, that the detective could not have known, and it is corroborated by the testimony I'm not finished, on the call from the defendant. So the defendant is making these statements with his wife on a phone call, and the person who's giving the information to Segovia is repeating it. So he could only have known it from the defendant.
Judge Miranda explained that the statement was not a confession, but rather a necessary explanation of the informant's independent source of knowledge offered specifically to rebut the defense's theory of Detective Segovia's fabrication. Under Section 90.801 Florida statutes, when the defense alleges that law enforcement improperly contaminated an investigation, the state is legally permitted to introduce prior consistent statements to rehabilitate the witness and rebut the charge of recent fabrication or improper influence. Once Ms. Peabody asserted that Detective Segovia fabricated George Jones's knowledge, Mr. Jones's recorded jail disclosures were no longer collateral matters. They became substantive evidence of an independent chain of communication from the defendant to the informant, as corroborated by Mr. Jones's recorded communications with his wife and Coach Randy Shannon. Because the defense failed to exercise due diligence in reviewing the discovery materials provided, Ms. Peabody's insistence that the informant's narrative was manufactured via a police report at the time remained in mere speculation rather than substantiated evidence.
Your Honor, the call is not the statement. The statement is completely different from the call.
Yes.
And that's what I am saying. The statement is what my concern was. And as far as the causeway is concerned, when I go across the causeway, not only is there an embankment, but there are trees. And there are video cameras. So if that were the case, then the state should have brought in a video tapes of it.
Hang on. In 2006, when you drove across the causeway...
They're the ones that brought the prosecution, Your Honor.
Right, but you're...
They're the ones that had it in 2006 or 2007.
Ms. Peabody, you're making statements that are so frivolous and out of the realm of reality. Because in 2006, we know that there were not cameras there. And on the causeway, the entire causeway is not blocked.
I don't know that. It wasn't brought in evidence.
By
How do we know?
It's pretty much common sense.
It's not really, Judge, because I've been here all my life.
All right,
I think we need to finish proffering so that we can have the jury
well, just a second. I am going to decide who's going to finish proffering. I understand that's what you'd like to do. Let me make the decision. That's why I'm sitting here. Secondly, the reality is the state has talked about this statement, and I think the defense is getting a little agitated because the context of the statement has never been discussed in the courtroom. And I think it's only fair when the attack is made that the detective is feeding information, that the state be able to put this information on the record, just like I'm allowing the defense to proffer things on the record. And when accusations are being made about the detective, which can be backed up by phone calls that maybe the defense isn't aware of or haven't had the opportunity to review or have decided not to review, they can put this information on the record. It is fair for both sides. I am letting you all speak much more than any other place would, or any other court, because I realize that emotions are very high. It makes no difference to me what the confession part that's alleged to have been made, which everybody is more privy to than I am, because I've never heard it or read it. I understand that it wasn't admitted into evidence, so I frankly don't really care. The part that I care about is if there is an accusation that a police officer was doing something that was inappropriate, like feeding information, which I have still yet to hear what that information might have been. That is something that I'm interested in because that's a whole other topic.
It was
And Your
twofold
Honor,
why
we
the
also
state was
brought
responding.
to the attention other
May
things
I?
that Detective Segovia has done that was improper, like outside the courtroom and threatening a witness.
Oh,
Ms. Peabody?
Don't say things you weren't present for and don't have any evidence of.
All right. I'm gonna call the agent. Ms. Peabody. Ms. Peabody. Maybe we should take a 5-minute break so that she can take a breath. Everyone out. Everyone out. Yes, everyone out, including you. Out. Out.
Judge Miranda declared a recess, utilizing the court's inherent authority to maintain courtroom decorum after Ms. Peabody introduced new, unsubstantiated allegations that Detective Segovia had threatened a witness. As said before in this video, under Section 90.104, when an allegation of law enforcement misconduct or third-party bias is raised outside the presence of the jury, the moving party must utilize a formal proffer to present the exact scope and substance of the proposed inquiry to the court. While Judge Miranda did not dispute the defense's right to pursue a theory of law enforcement bias under Section 90.608 Florida statutes, she countered that the Florida Evidence Code does not permit counsel to anchor an official proffer in speculative statements devoid of a proper evidentiary foundation or a good faith factual basis. After that, the trial continued for several days, and on March 2, 2026, a mistrial was declared after the jury deadlocked with only a single juror voting to convict Jones, while the remaining 5 favored acquittal on the single count of second-degree murder. This case underscores the critical tension between zealous advocacy and the strict evidentiary boundaries that underpin a fair trial. When Ms. Peabody introduced uncorroborated claims of police misconduct and fabricated informant testimony in support of a theory of third-party guilt, it challenges the structural integrity of the adversarial process itself. Judge Miranda's intervention highlighted what the court perceived as a factually detached narrative regarding third-party liability, relying on legally inadmissible polygraphs and allegations introduced without facts and evidence. By blocking these legally inadmissible elements, the court affirmed its role as a gatekeeper of fairness, ensuring that the legal proceedings are not derailed by sensationalism or surprise. Instead, the court ensured that the proceedings remain anchored on a foundation of evidence following the proper procedure of the law. Ultimately, these judicial actions safeguard the constitutional balance, ensuring that any future trial or subsequent verdict rendered is grounded in a transparent, verified, and lawfully admissible evidentiary record. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more case analysis.